So this is the Riot Act, right? And it's 1714. An act for preventing tumults and riotously assemblies and for more speedily and effectual punishing the rioters, right? So this is like one of the original prints of this act. It goes down through here, and then it's got a full page there, and then this top part here, right? Now, this act actually, you've got to have there's three qualifying points for this act. You've got to be unlawfully, riotously, and tumultuously assembled, right? Now, in order to qualify for that, you have to be unlawfully assembled and riotously and tumultuously. So if you have persons who are using Parliament and they got a court order from a court, right, over 20 people, right, they're not unlawfully assembled and it cannot be a tumultuous assembly. So you're removed from being able to qualify from that. And if you've got under 20 people, you're never tumultuously assembled anyway, and you can't be unlawful. So it actually disqualifies you from these circumstances here, right? Now, this act applies to over 12 people. If you don't qualify any of them, it applies to 12 people, right? Now, in this act, the authorities get to read out a declaration, right? And it gives the parties an opportunity to declare whether, if it's under 20 people, that they're using the authority of Parliament or not. And if they're over 20, it gives them the opportunity to show their court order, right? Which will protect them, because it puts them under Parliament's jurisdiction as stated by Edward Coke, right? So you can only qualify for this if you're not using the jurisdiction of Parliament, right? Now, also, for this act, it's a little bit like the Malicious Damage Act later on in this act, where it's actually damage to buildings, serious damage to buildings and things like that. It's not like the current Criminal Damage Act, which is compatible with privileges when it's usually minor or small damage, and that's because the authorities need to use it as well. But when you are petitioning Parliament and using messenger process, you are the authorities, right? You are one of the authorities. Now, the Malicious Damage Act didn't necessarily actually have in it an explicit privilege usage, but if you take into account the Bankruptcy Act, it says you cannot use privileges of Parliament in that act, right? So it's against using privileges. And the other thing about this act is that it's talking about there are certain protections for clergy and things like that, right? But what I've realised after reading this act, when it comes to exemptions and protections, what it's actually saying is that it's removing you from accountability for civil claims, right? And this is actually compatible with the Claim of Right Act 1689. In the Claim of Right Act 1689, it says that you can't use protections for civil debt, right? So if people were to damage a building or pull a building down or something like that, then they can't get out of being liable for paying for it according to this act. But there's an argument whether or not that parliamentary privilege removes you or not. But what I would say is it does remove you from the courts. You might have to answer to Parliament, why you pulled the building down and to pay the costs. But that paying for the costs applies to if you didn't qualify for those first three things to remove you from that jurisdiction. Now, but does the 1688 Bill of Rights apply? All prosecutions and are illegal? Well, that's a good question, because, like, for example, in the Highwayman Act, when you're apprehending a highwayman, it says that you will be pardoned of all offences, right? And so that Highwayman Act's a good example of it is possible to be pardoned of all offences if you're in pursuance of an important matter. It can be done, it can be possible, but it definitely still removes you from the jurisdiction of the local court. You might have to answer a civil debt to Parliament, right? But that is debatable, unquestionable in this. But the main point in this is that actually you don't qualify to be under this act for this offence if you are using the jurisdiction of Parliament officially, right? Either under 20 people or if you've got court order. And so you're not actually liable for the felony, the crime of felony, because this creates a crime of felony, and obviously you've got death penalties and things like that that can come into it. So if you are using the jurisdiction authority of Parliament, you cannot qualify for the felony. That's the main part of it. But you've got to make your declaration. And this is what people are doing now. The police have been given powers to issue these dispersal orders under modern law. But that's when you get your opportunity to tell them what you're doing and to declare that you're using, Parliament jurisdiction and so forth, which, if you've got a petition or cause to Parliament and you've got signs and notices for it and you're advertising it, surely you're actually in the process of giving notice for it. You're giving notice, and under modern law, under the criminal procedure rules, the police have got to recognise the rights of the defendants and the needs of other cases. So if the police are playing ignorant and they're saying, oh, this isn't a parliamentary cause or we don't recognise it, then they're actually breaking the criminal procedure rules, right? But I think young people under a certain age are exempt from that dispersal order anyway, but this is just an example of this act, right? And when you read that Sir Edward Coke book and all the other basis around it, it actually all fits in to it